Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to a very special edition of Our Curious Amalgam. I'm Alicia Downey. The annual spring meeting of the ABA Antitrust Law Section is the premier event of the antitrust and consumer protection law world. At the 2023 meeting, the Our Curious Amalgam team recorded interviews with more than a dozen leaders of competition agencies from all over the world. We asked each of them about their current enforcement priorities, what enforcement trends they see on the horizon, and tips for practitioners representing parties under investigation. We also got to know our guests a little bit better on a personal level. The title of today's episode is What's Happening in Canada, Brazil, and Taiwan? Conversations with competition law enforcers at the 2023 spring meeting. In the next half hour, we'll bring you the interviews that my co-host Honora Wong and I conducted with the leaders of the competition agencies of Canada, Brazil, and Taiwan, respectively. In our first segment, Honora Wong finds out what's happening in Canada from Matthew Boswell of the Canadian Competition Bureau.
Hello and welcome to Our Curious Amalgam. I am your host, Honora Wong. As you know, we at the OCA discuss all things about competition, consumer protection, and data privacy here in the United States or anywhere in the world. Today, I've got the privilege to speak with the enforcer of our neighboring jurisdiction that's just north of the border, Canada. Joining me today is Commissioner Matthew Boswell, who was appointed to the Competition Bureau of Canada in March 2019 for a 5-year term. Commissioner Boswell first joined the Competition Bureau in January 2011 and served in various senior management positions throughout the organization, leading merger reviews and directing major investigations targeting criminal cartels, abuse of dominance, and deceptive marketing practices. Before joining the Bureau, Commissioner Boswell worked in a private practice in Toronto, served as Assistant Crown Attorney with the Ministry of the Attorney General of Ontario, and was a senior litigation counsel at the Ontario Securities Commission, where he primarily prosecuted the securities fraud and related matter. Welcome to the OCA podcast, Commissioner Boswell.
Thanks very much, Honora. It's good to be here.
It's our pleasure. So, Commissioner Boswell, before we go to the several questions that we are interested in learning about your agency's enforcement, could you give us a high-level introduction of your agency and what does the agency do?
Sure, yeah. The Competition Bureau of Canada is an independent law enforcement agency that protects and promotes competition in Canada. We also enforce consumer protection laws related to deceptive marketing primarily, and we advocate throughout Canada for pro-competitive policies. That's basically what we do.
Is it the equivalent of FTC? Is that fair to say?
Almost. We don't have the privacy enforcement component that the FTC does, but very similar, yes.
That's good to know. So what is your organization's top enforcement priority, I guess, for next year?
I think to answer that, it's maybe not directly an enforcement priority, but we're seeking to have our law in Canada amended to make the Competition Act fit for purpose for the modern digital economy. And we've been advocating for that for some time, and we're getting traction now in Canada on that. The Government of Canada has launched a consultation that's going on right now, seeking input on how the law should be brought up to snuff, if you can call it that.
Yeah.
The law hasn't been comprehensively reviewed since it came into force in 1986. This version of the competition law, Canada's actually had a competition law since 1 year before the Sherman Act.
I know.
Always have to make that point.
Yeah.
So we're pushing forward on advocating for changes, and in some of the key areas, our merger law is arguably one of the weakest merger laws among all our key trading partners, G7 partners. So we have a lot of recommendations on how we can fix that. Mm-hmm. So that's a very important priority for us over the next year, is to, help the government move forward and amend the law. A second one would be to effectively implement some initial changes they made to our law last year. And that includes new criminal provisions prohibiting wage fixing and no poach agreements in Canada. as well as a very explicit provision on the consumer protection side that deals with drip pricing, a very problematic conduct in terms of when it comes to consumer protection. I think just to round out this answer, we are going to continue to focus, as we have throughout my term as commissioner, on vigorous enforcement of the law. We've brought more cases, more merger challenges in the last few years than in sort of decades before. And that is a key priority for us as part of our strategic vision, and we will continue to bring cases. We're willing to litigate, we're ready to litigate, and if we can't get an appropriate resolution, we will go to court, and we're making that message very clear to the Canadian business community and legal community.
Right.
And just one other thing, we have a large ongoing cartel investigation into bread price fixing in Canada, where the alleged conduct went on for 14 years and involved the key bread makers in Canada, as well as several grocery retailers. It's a large investigation, and we really are focused on pushing that forward this year.
Oh, that's great. That's very informative. I just have like two maybe follow-ups and maybe notes to the listeners. First of all, Canada did have their competition law passed a year before the U.S. So Canada has been trailblazing, like, historically and now, also with the digital economy law amendment. So I guess one more clarifying question would be the initial changes that has been adopted last year, which is 2022, regarding no poach and wage fixing. Is that criminal now in Canada?
It absolutely is criminal. Well, sorry, not right now.
Okay.
The law was passed last summer in June 2022, but the government gave a year lead up for it to come into force to allow the business community, the HR community, all those folks to know that this was coming, so that they could get their affairs in order and not be committing crimes as of June 23rd, 2023.
Right, and maybe apply for leniency.
Potentially, yeah. We'll see. We'll see on June 23rd or June 24th, 2023.
Yeah. And then I guess a second high-level question. What is the most important trend that you see developing in competition law enforcement in the near term?
Well, as I've already mentioned, I think the trend is, it won't be a new trend, it'll be a continuation of a trend, which is aggressive, vigorous enforcement. At the Bureau, we're asking ourselves much more frequently than we ever did in the past, what's the risk of not taking action? So we are, when we ask ourselves that question and we weigh that and analyze the evidence, we are coming more often to the conclusion that the best thing to do, rather than a remedy that doesn't adequately, fully address the competition problem, say, well, if we can't get that, then we're going to go to court. We're going to take the matter, and with that comes the reality that we're not going to win all our cases. Right. But that we're going to take them, and that we're building our litigation capacity internally, and have been doing that for several years. And we're demonstrating that to the Canadian market. So that's kind of it's not so much a new trend as a continuation that we're very much committed to in Canada. Yeah,
I have a follow-up question that might be a little bit on the strategic thinking of the agency. So this is the litigation, the cases that the agency is bringing is happening against the background that the law is also being amended, right? So is there attempt or effort to try to actually set some precedent or winning some cases that's helpful for the legal change, like in the amendment that you are advocating for? Or what's the thinking behind these two?
Well, I think, we make our decisions on bringing cases based on evidence. It's not with any ulterior motive in mind. Yeah. But it has the sort of double dividend, if you can call it that, of when we bring cases, we get more clarity on the law, we get more jurisprudence, which is something that, for those of your listeners who know about Canada, there's very limited jurisprudence in competition law in Canada, simply because, in my view, not enough cases have been brought. And even in the last 24 months, we've had multiple instances where the law has been clarified one way or the other. Sometimes not with the result we want, but it has helped clarify the law. It lets us know where we need to go next time, how to address problems. And it also sort of points out to legislators where some of the problems might be in the law.
Yeah.
To allow them to fix it when they're going about thinking about how to amend it.
This is very helpful and insightful. So I guess a third high-level question would be, what advice do you have for practitioners who want to be effective in front of your organization?
Well, going back to what I said about evidence, and our entire structure is obviously based on evidence. We're a prosecutorial model.
Yeah.
And to practitioners, it's whether you're on the side of a party complaining about somebody's conduct or responding to an investigation or trying to get a merger through in Canada, it's know your evidence.
Right.
And we've had unfortunate instances where we've had people come in and they're trying to make submissions and claim things, but without pointing us to the evidence that supports their position. Or in some instances where they haven't even really got a grasp on their own evidence.
Right. Where
we're pointing out things in their own documents.
Right.
That they clearly weren't aware of or hadn't taken the time to prepare.
Right.
And, as a law enforcement agency, if you want to deal with somebody and see them as credible, they have to come to the table prepared. They have to come to the table with reasonable lines. And if they're not doing that, then it's not going to go well for them when they're interacting with our organization. So it's really know your case.
Right.
And be reasonable in terms of how you're dealing with us, because if you're not, and go back to the first point, you leave us with no choice.
Right, and it hurt your case even more, right? Yeah, so
exactly.
That's very fair and good advice. So I guess a final high-level question is, do you have any interesting hobbies or accomplishments outside of the competition law that you care to share with us?
Well, hobbies, I can answer that by saying I'm kind of addicted to Peloton.
Oh.
You wouldn't know it from my physique, but I do spend a lot of time on the Peloton, and it has sort of the great advantage of also being a great place to think through all the issues that I'm dealing with at any given time and come up with solutions.
Right.
I do want to mention two achievements, kind of hilarious. I was on the show Cash Cab. I'm not sure if you're familiar with that, with some buddies about 10 years ago, and we got every question right.
Right.
Yeah.
Was there a cash prize?
There was. We won $900, I think, and then promptly went out to celebrate and spent most of it.
May I ask what year was this? I tried to get inflation right. What, $900?
It is around 2010, 2009, maybe later. I can never. I do have it recorded at home, but
you definitely could have a good time with that $900.
And I guess the second one, which is always a fun anecdote, is I assisted in apprehending a bank robber many years ago, and as a result of that, got an award from the Toronto Police Service.
This is before or after you get into Peloton?
This is long before Peloton. Long before Peloton. It was when I was a Crown attorney, so I was a criminal prosecutor.
Well, that's very, very impressive. I don't think I've heard many people mentioning something on that level. Thank you so much.
Thanks, Honora. It was a pleasure.
Yeah. Until next time.
Cheers.
And welcome to Our Curious Amalgam. I'm Alicia Downey. With me today is Alexandre Cordeiro, who is the president of the Administrative Council for Economic Defense, CADE, in Brazil. Today, we'd like to ask him a few questions here at the spring meeting. And the first one is, currently, what are the enforcement priorities for your agency?
Hello, Alicia. It's a pleasure to be here. Thank you very much. So we must say that there are some top priorities for CADE's antitrust enforcement for 2023-2024. In terms of merger review, operations entailing vertical integrations, for example, are extremely relevant issue. Last year, we assessed important cases involving vertical integration and theories of harm related to this subject, including risk of market foreclosure and self-preferencing practices. This matter will certainly play an important role on merger control conducted by CADE in the following years, but also with regard to conduct, following internal assessments, our recommendations of the OECD 2019. In our pre-review, we have created a specialized unit to assessing cases involving unilateral conduct. In this sense, CADE is really prioritizing those unilateral conduct. And we have a lot of good cases and important cases involving actually not just unilateral conduct, but also unilateral conduct related to digital economy. For example, we had a case that is our delivery platform in Brazil called iFood, and is related with exclusivity clause. And we did a interim measure to stop the exclusivity clause, and later we did a settlement that solved the problem. We had the same case in a platform in Brazil that is related to digital economy with gyms. So it combine all of gyms and also people that use those gyms. You pay a pass for them and have access to all of those gyms in Brazil. And they also had a exclusivity clause with those gyms, and it's they were foreclosing the market for new platforms. So we also did a interim measure of prohibiting the exclusivity clause, and later we did a settlement that could solve the problem as well. So the other function and the other main role that we're playing in is a very important priority is the advocacy competence. So the advocacy in CADE is growing a lot. Usually we do by our Department of Economics, and we have a very strong relationship with other institutions, for example, the sector agencies, aviation, oil and gas, and energy. So we have this very tight relation that we can talk to them, understand what kind of regulation they are doing, and help them in terms of competition. Which kind of regulation could be better, could be, better for the competition, but also protecting the issues and the things that they want to protect as well.
Great. That's all very good to know. Let's talk about trends. As you look ahead, do you see the enforcement targeting certain types of conduct or certain sectors more than others?
No, actually, CADE, now in Brazil is a big deal. I think that abroad is a big deal. The oil and gas, so energy sector it's a big thing in Brazil. Digital economy, for sure, in every country is big as well. But I think that what concern most the antitrust authorities right now is the general approach about the goals of antitrust. This is a big thing. Everybody is discussing that. Should we care about sustainability, labor market, taxation, or just efficiency and consumer welfare standard? So we have been watching what's happening in the rest of the world. We watching what's going on here in the United States and also in Europe. We are open to discuss everything. We don't close our eyes for changes, but we still in Brazil holding up and say, okay, let's stay with the beginning of those things. Let's understand what's happened in the past. Let's understand why this changing is happening, where it's going, and we have to calculate the cost and the benefits for this change. That's the thing. So in CADE, we're watching, we're carefully, but we're still with the consumer affairs standard for now. And the goal of antitrust is the consumer, the efficiency, and I think that it's one thing that we do well. But I'm not saying that those other things are not important. What I'm saying is, probably there is better institutions that can do those issues than CADE. So we have like institution for sustainability, for labor, for taxation that is not related to antitrust and can do a better job.
Yeah, well, you're certainly echoing the debate that's going on here in the United States too, and it's far from being resolved. Now, I'm sure you have practitioners who are local working on matters before your agencies, and I'm sure you have international practitioners too who are involved perhaps in getting a merger cleared. What advice do you have for those practitioners to be most effective when they're before CADE?
It depends. This is a very broad, broad question. What I used to say that it's a good advice to advocate in CADE or to be in front of CADE, defending your case, is trust in the institution. It doesn't matter if it just merger and acquisitions or just cartels. If you are cooperating with CADE, truly cooperate. And CADE is there for listen. The idea of CADE is not just punishing. That's not the idea. The idea is protect the competition. And protect competition, sometimes the educate role is much more important than punish someone. So that's why we think that it's important the bar, when it's in front of CADE, be transparent, be clear. Because the penalty for not to be transparent, for not to be true in CADE is high, and we take this very seriously. And also, when we're talking about merger and acquisitions, there is a lot of asymmetry of information. I used to say that CADE take care of every market. For example, chocolate and aviation, for example. One day is chocolate, the other one's aviation. We are not specialized in any sector, but we are specialized in competition. We know what we want, and we know what we're looking for. So the idea to get a better decision in CADE is when the party goes there, give us the information. It will be easier, because if you don't give the information, we're going to get this information anyway with the other competitors, with the market.
Switching gears as we head toward the end of our discussion, we do like to get to know the folks that we interview a little bit better on a personal level. So we wanted to find out if there was anything fun or interesting that you do outside of your professional life that you'd like to share.
Yeah, I have two hobbies that I like. One is sports. Actually, I play two sports that I really like. I play golf, and I'm curious about this sport. Actually, my son also is playing golf. I'm sometimes traveling Brazil to go in a tournament with my son. So this is a fun part. But also I play beach volleyball. I used to be a professional volleyball player when I was young.
Wow!
So this is very nice, and I still playing a little bit. No, I'm
do the volleyball
old.
skills translate to golf at all, or it's just you're generally athletic?
No, there isn't anything to do volleyball and golf, zero. But just because I like sports, and I changed it to golf. Now I'm getting old, so I need to change the sport. Volleyball is not so. It's a very strong and fast sport, but it's still a nice sport, and
Great.
I like.
Well, we're thrilled to hear about it, and good luck on your golf journey. Thank you so much for joining us.
All right, thank you very much.
This is Alicia Downey. For our next segment, I'm speaking with Andy Chen, the Vice Chairperson of the Taiwan Fair Trade Commission. The Taiwan FTC is an independent agency that enforces the Fair Trade Act and the Multi-Level Marketing Supervision Act. Since its formation in 1992, the agency has been responsible for investigating unfair trade practices and various types of restraints on competition, including monopolies, anti-competitive mergers, and cartels. This is Dr. Chen's second term serving on the Commission. His previous term ran from 2007 to 2010. Before his reappointment, he was a professor, dean, and chair of the Department of Financial and Economic Law at Chung-Wan Christian University School of Law. And welcome to Our Curious Amalgam, Vice Chairperson Andy Chen of the Taiwan Fair Trade Commission. What we'd like to ask you first is, what is the Commission's top enforcement priority in this coming year?
Thank you, Alicia. Thanks for having me in this program. As you have introduced, the Taiwan Fair Trade Commission is the medium-sized competition enforcement agency, so setting priority is very important for us. We just released a white paper on competition policy for digital economy. And in that white paper, we kind of setting up the priority we need to do in the next few years. So, for example, we need to upgrade our enforcement capability in terms of the technological issue. And we also need to pay more attention to the various different types of conduct that has occurred in the digital economy. And in the long run, probably we need to revise our law. For example, under current law, we can only punish cartel that enter into among competitors, not the vertical relationship. So vertical cartel is not within our jurisdiction right now. But as you might have known, most of the cartel in digital era occur vertically. So, for example, we mentioned a little bit about the hub and spoke cartel. That will be under our radar. So that is something that is a loophole we need to kind of close the gap. And also, after the pandemic, we have seen a couple of companies try to take advantage of the economic recovery to engage in price fixing. So for the past couple of months, we actually have investigated a couple of cases concerning price cartel. And I think that is also an area we need to pay attention to in the next couple of years. So probably that's what is currently our priority for the next couple of years.
Oh, thank you very much. For those listening, we'll make sure to get a link to the white paper on the web page for this episode. So we'll I assume it's available on the website.
Yes, I think the English version of the abstract of the white paper is going to be released this week.
Turning to our next question, I think you mentioned the fact that you're keeping an eye on vertical relationships in the digital space. What are the other important trends that you're seeing developing within the competition sphere in Taiwan?
In Taiwan, I think the trend in Taiwan is right now we pay more attention to unfair competition issue in addition to the antitrust issue. So especially during the high inflation period, people complain a lot about the skyrocketing of the prices. And so more and more we have seen that we are dealing with kitchen table issues, such as the price for eggs, the shortage of egg supply, the price for rice, something that is important for daily life. And it really sometimes it really create some kind of challenge for our agency because those kind of investigation require a large scale market investigation and sometimes in collaboration with other agencies. So that's one of the important development in our agency. The second important development in our agency is that we have increased what we call the bonus for reporting cartel violation. So to give the incentive to the general public to report the cartel behavior if they know it. So I think we have seen its effectiveness in attracting people to report cartel recently.
So you're talking about what, a financial reward?
Yeah, yes, financial reward.
Wow.
It could go up to the maximum rewards would be 100 million new Taiwan dollars.
Okay. And the other question we have is for practitioners who want to be effective in front of your agency, perhaps in a contested matter regarding conduct or merger control, what advice do you have?
My advice to them is to probably the lawyers who are representing their clients, they probably need to take some time to read our guidelines or guidance. We do have several guidelines concerning, for example, market definition and how to evaluate the competitive effects, and especially how you can apply for merger review. So these are very important guidelines. Maybe you could get a little bit familiar with. And the second suggestion would be we have this what we call the internal manual for doing economic analysis, and that is really what we will use. The tools we stipulated in the manual will be the tools that we are going to use. So I strongly suggest that the lawyers could also again get familiar with these kind of tools. And the third advice is that even though within our agency we do have the Department of Economic Analysis, but economic analysis departments not talk to the enforcement department very frequently. So sometimes it might create a problem for us that the enforcement team may not know very well about the economic analysis. So on the side of the lawyers, so if you can, I know lawyers are supposed to be good storyteller. So each time when you are filing materials or document to our agency, you try to tell a story that could combine both the economic or management theories together with the antitrust law. They will facilitate our reviewing process and might get a more favorable result for the clients, maybe.
Yep, that's excellent advice. We also like to get to know our interviewees a little bit better personally. I want to ask if you'd like to share with us any interesting hobbies or accomplishments outside of your professional life.
Oh, okay, yeah. I think I like traveling and music. I travel a lot. I like to see the situation and different culture around the world. It's kind of a recharging your life a little bit. And also I like music. I can play violin.
What kind of music?
Music, basically classical music, but sometimes jazz. And I can play a little bit of violin.
Oh, that's nice.
Yeah, just enough, not professionally, but just enough to show off to my kids. Okay, and I like to sing. I used to be a not bad tenor, but as you aged, so your lung the capacity of a lung kind of shrink.
Oh, good. Well, now you have your violin to fall back on then.
Oh, yeah, that's true.
Great. Well, I want to thank you so much for
being with us.
Thank you,
Alisa. Thanks for having me.
That's all for today's episode. Thank you to my co-hosts and to all of our distinguished guests. We're featuring interviews with many other international enforcers in past and future episodes of Our Curious Amalgam, so be sure to subscribe wherever you get your podcasts.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.